Testing. Well, thank you all for coming. I'm Baron Soka, president of Tech Freedom. This is a day of firsts for us. It's the first event we've had here in our new space. It's probably the first time many of you have been in this building. I've walked past this building for years and really had no idea what it was. It's an architectural treasure built in 1923. It's preserved in all its historic forms, and the Methodist Church is kind enough to lease the building out to nonprofits like Tech Freedom. We're the first, this will surprise you, the first technology policy think tank based here at the Methodist Church, and we're looking forward to talking about technology with other organizations who are trying to change the world in their own way. This is also the first time we've had C-SPAN cover a Tech Freedom event, so I'm delighted to have them here. It's our first time with Commissioner Pai, who I'm going to introduce in a moment, and it's our first time with our new format, which is a tech briefing. So we handed these out over at the entrance. This is our attempt to adapt our motto, which is Richard Epstein, the great philosopher of law. His slogan is "Simple rules for a complex world." It's something you'll hear from us a lot. And the tech briefing is really our attempt to do simple bullets for complex issues. So we're going to do those on a number of issues in the future. This one attempts to cut to the heart of what unlocking is about, and that's exactly what you'll hear from us at this event today. The hashtag today is unlocking, so make sure to join our conversation on Twitter. And I will say, with compliments to our Methodist friends, that this event space has the single best Wi-Fi of any event space I've ever been in DC, and I know that because I ran speed test. So if anybody tells you that business broadband is inadequate, I think that the Methodists are leading the way in this respect. So I will just mention we have another event coming up in July. It's either on July 8th or July 11th. Stay tuned. On the past, present, and future of COPPA, the Children Online Privacy Protection Act. So stay tuned for more on that. Without further ado, I'm going to introduce Commissioner Pai and then turn it over to our distinguished panel. Commissioner Pai is my favorite commissioner on the FCC now, and in general a great commissioner. And in particular, I like Commissioner Pai because he's realized that the job of the FCC is not merely of FCC commissioners is not merely to cover telecom policy, but areas like this one that intersect with telecom policy. And what you'll hear today is that this is one example of where government in some areas can actually reduce competition in markets that in other areas people complain about not being competitive enough. And so my hat's off to Commissioner Pai for realizing that cell phone unlocking is one of those ways that we can actually empower consumers to choose for themselves, that might be better than some of the other regulatory proposals people have made for governing wireless. So let me just ask you to turn off your cell phones and again, join us on the unlocking hashtag, and I'll turn it over to Commissioner Pai, and then we'll introduce our panel.
Well, thank you, Baron, for that kind introduction, interspersed though it was with all sorts of undue praise. I really appreciate the invitation and look forward to participating in this conversation this afternoon as well as in weeks and months to come. You know, it's a little unusual in Washington to discuss an issue where Republicans, Democrats, and independents can find common ground. But President Obama, senators and representatives, FCC commissioners, and the American public are reaching a consensus on a pretty simple proposition. And that proposition is that consumers should be allowed to unlock their cell phones and switch wireless carriers without being labeled scofflaws. Now, to the proverbial man of the street, it's absurd that we're even discussing this issue. I mean, how did we get to the point where a consumer could be criminally prosecuted for unlocking a cell phone? Well, there are two aspects to the answer. One involves technology, and the other, the law. First things first, most wireless carriers lock the phones that they sell so that they will only work on that carrier's network. So if you purchase an iPhone from one carrier and want to switch to another carrier at the end of your 2-year contract, you can't do that unless you unlock your cell phone. Unlocking requires you to access certain programming within a phone, say by punching a specific sequence of numbers on the keypad, in order to allow the phone to function on another network. For those of you with refined tastes, I should note that it's not like that scene in the movie War Games where Matthew Broderick uses a pop top on a soda can to make a call from an unlocked payphone. That's something completely different. Next, enter the law, specifically the Digital Millennium Copyright Act, or DMCA. The DMCA, as many of you know, was designed to prevent digital piracy, such as when someone distributes on the internet a song like Blondie's Call Me, or Carly Rae Jepsen's Call Me, maybe. To do that, the DMCA prohibits consumers from deactivating the DRM software or other protections designed to prevent access to a digital copyrighted work. Now, it wasn't until about 10 years ago that anyone thought the DMCA might apply when a consumer unlocked his phone. But the DMCA swept up cell phone unlocking through a technicality. Locking of a cell phone prevents access to software in the phone, such as the mobile operating system, when it's used on a new carrier's network. And so, when you unlock a cell phone, technically you are circumventing a technological measure, to use the DMCA's word, even though nobody thinks that unlocking a phone is the equivalent of piracy. Now, fortunately, the DMCA contains an out for situations like this. The Librarian of Congress, just down the road, who oversees the U.S. Copyright Office, is entitled to grant 3-year exemptions so that consumers aren't subject to those DMCA anti-circumvention provisions. And in fact, the librarian did just that in 2006 and again in 2009, so that consumers could unlock their phones without fear of prosecution. But the third time wasn't the charm. Last October, the librarian declined to extend the exemption for cell phone unlocking. And as a result, a consumer who unlocks his mobile device now can face civil and criminal penalties under copyright law, even if the contract with his carrier has been fulfilled. And to me, this is a classic case of the government solving a problem that simply doesn't exist. The free market was working just fine in this space before the librarian's decision. For instance, a bipartisan FCC report issued earlier this year found that prices in the wireless marketplace were down and that investment has gone up. Similarly, more manufacturers are developing innovative mobile devices, and consumers, all of us, are reaping the benefits of that. And wireless carriers certainly don't need the federal government's help. They already have contract law rights, such as early termination fees, to ensure that customers live up to the terms of those contracts. And so, adding heavy-handed copyright penalties, including hefty criminal fines, simply marries the sledgehammer to the fly. And so my position is pretty simple. The relationship between wireless carriers and their customers should be governed by contract law, not copyright law, and certainly not criminal law. While there's broad support for overturning the librarian's decision, there's also an ongoing debate over the best way to accomplish this objective. I've been thinking about this issue for some months now, and here's where I stand. First, I don't think that we should kick the can down the road. We should fix this problem permanently. We don't need to have this exact same debate 3 years from now, 3 years after that, like an extended version of the movie Groundhog Day. I can assure you that the case for criminalizing cell phone unlocking isn't going to get any stronger over time. Second, we don't need to give the FCC any additional authority. I recognize that it's not the norm for an FCC commissioner to ask Congress not to add to its power. But the FCC didn't create this mess, and we are not in a position to clean it up. The problem is one of copyright law, and Congress should fix that problem directly. Third, we shouldn't interfere with the freedom of contract. Consumers today can choose from a wide variety of providers, plans, and phones. And so we shouldn't restrict carriers' ability to offer consumers better, faster, and cheaper options. Fourth, we also should protect those who help consumers unlock their phones. Unlocking can be as simple as dialing a code on your phone, but it's often more complicated than that. I know that I certainly couldn't pull my phone out of my pocket and unlock the phone right now, and I think others are probably in the same boat. So helping consumers exercise their right to unlock their phones shouldn't be a crime. Fifth, this debate was inspired by cell phone unlocking, but the DMCA actually cuts a much wider swath. The anti-circumvention provisions in that law apply to netbooks, tablets, PDAs, virtually any mobile device. Consumers shouldn't be put in the position of migrating some of their electronics, but not others, from one wireless carrier to the next. And so let's make sure that all wireless communications devices are included in the fix. Sixth, and finally, let's keep our focus on the narrow issue at hand. I know that many people, maybe some in this room, favor broader reform of the copyright laws. And I know that many other people oppose broader reform. But I think that that's a debate best left for another day. Right now, there's wide support for removing cell phone unlocking from the ambit of copyright law. So let's push that proposal across the finish line. And my fear is that if it becomes entangled in more controversial issues, that proposal might get stuck in the starting blocks. Unfortunately, doing all 6 of these things isn't complicated. In fact, Congress could accomplish them right now with a one-page bill simply by amending the definition of circumvention in the DMCA. But that amendment would simply clarify that the definition of circumvention excludes circumvention initiated by or on behalf of an owner of a wireless communications device solely to connect that device to a wireless communications network. This basic fix would restore the common sense, market-based approach that ruled the day until last October's surprise. So these are my brief 2 cents. I look forward to hearing from our distinguished panelists, Baron, Brian, Chris, Jerry, and Larry. Working together more generally, I'm hopeful that we can end unnecessary government intervention in the wireless marketplace and ultimately score an important victory for American consumers. Thanks again for having me.
Thanks so much for coming, Ajit. Everyone hear me? Our panel here today includes my colleague Ryan Radia from the Competitive Enterprise Institute. CEI is a co-sponsor of our event today, as they have been for many of our events in the past, and I'm sure will be for many of our events in the future. To his right is Chris Lewis, Director of Public Relations at Government Relations at Public Knowledge, which we've worked with a number of times. We don't agree on everything, but this is, as Ajit said, this is a rare issue where people of all stripes can certainly agree that we should get government out of the way to encourage competition. Sitting to Chris's right is Jerry Brito from the Mercatus Center. Jerry's also an expert in tech policy and slightly more academic than we are over here on Capitol Hill. And finally, Larry Spiewak at the end is president of the Phoenix Center. Larry's been covering tech and telecom policy for many years and is here to push back in a healthy way against the consensus here. So let me actually start with Larry. Larry, you've been a bit of a naysayer here, so what's the deal?
So colorful at the Phoenix Center. And thank you, by the way, Baron and Ryan, for inviting me to participate. It's very kind of you. You know, when I've been dealing with handset unlocking since easily 2007, when this first raised its head with the notion of wireless Carter phone. So I think as I was preparing for the debate today, there's really 3 discrete questions here that we need to discuss, and I think they need to be sort of parsed out if we're going to have an honest discussion. The first discussion is, that's not my phone, that's Jerry's phone. The first question is the generic concept of handset unlocking good or bad? And I think a lot of people get that confused with everything else, okay? Let's assume we just have a contract regime. If I give you a phone that I could buy unlocked for $650 and I get it for $200 at a subsidized rate, I don't think it's unreasonable for me not to be able to unlock that phone for 2 years so that I don't go run off and sell it in the third market. If I want to buy an unlocked phone, I can do so at full price. They're fully available. If I want to get a phone at the end of my contract unlocked, any carrier will do it who has a locked phone. So it's not really a big deal. We've actually looked at the economics of this, and it turns out that because of the complementarity of the phone and the handset, what's going to end up happening, and you're starting to see this, is that if you eliminate the ability to subsidize, the price of wireless service is not going to change, but by definition, the price of the handset's going to go up. All right, so that's issue number one. And also just quick thing about interoperability. When we hear talk about, oh, I want to take my phone to one network next. This is a GSM phone. It will not work on Verizon's network or Sprint's network. So just because I can unlock it doesn't mean it's interoperable. And I think there's a lot of confusion about that. Point two, now we have the Registrar of Copyrights decision. If you read the decision, okay, which was done in a dispassionate rulemaking that was open for notice, open notice and comment, okay, what the registrar essentially found was that given all of the amazing choices available for consumers for handsets, we don't need the non-circumvention. Now, that raises the third issue, which is, do we want to have copyright as an added enforcement against jailbreaking? Are we worried about the men in the black helicopters swooping down on grandma because she's jailbroken her phone? That's a separate issue dealing with the DMCA, but I think we need to put all three of those questions into very severable categories so we discuss each accurately.
Thanks, Larry. And I just want to call everyone's attention to that, to our tech briefing that you have here, where we try to break down in again, simple bullets, the difference between unlocking, jailbreaking, and rooting. You'll hear those terms thrown around a lot today. They're confusing. They really are fundamentally technologically similar. They have to do with different purposes. Primarily today we're talking about unlocking your phone so you can use it on another carrier's network. And to clarify, that's something that your carrier can do for you by sending a code to the phone, but it's also something you can do by replacing the bootloader or essentially the operating system on your phone. So Ryan, how do you respond to Larry, and can you give us some background here on the issue?
Sure. And thanks, Barron and to Tech Freedom for co-sponsoring this event with us. This goes back, as Commissioner Pai mentioned, to the 2006 decision by the Librarian of Congress in consultation with the Copyright Office to exempt the unlocking of cell phones to switch carriers, which was renewed in 2010. However, any phone purchased after January 26, 2013 cannot lawfully be unlocked because of the late 2012 decision. That's by way of brief background. The findings of the librarian were, among other things, that carriers generally let users unlock their phones when they've met certain conditions. And that's correct. If you are a customer of a carrier in good standing after a period of time, not even necessarily after you've completed the entire duration of your contract, you may be able to unlock that. However, that is not universally the case. There are some carriers that restrict who can unlock phones. For instance, some carriers only let you unlock your device if you are a subscriber of that carrier. So even if you have purchased a phone from someone else who has completed their contract, the carrier may not be willing to help you unlock that device, even though you lawfully own the phone. To Larry's point about preventing people who have promised not to unlock their device from doing so, I think we all agree that these agreements should be enforced, that the contractual provisions between subscribers and their carriers to stay on a plan for a period of time, typically 2 years, should be enforceable. But the question is, what should the remedy be if one of the parties, here the subscriber, breaks that agreement? We could, on the one hand, have a common law style approach where we allow for what is known in contract law as an efficient breach. But what we have today is a regime where if you unlock your cell phone, you have not only violated the contract, you have violated the Digital Millennium Copyright Act and subjected yourself to civil penalties, regardless of whether the decision that you made was desirable. Likewise, if you unlock your phone willfully or for financial gain, you may be subject to criminal penalties. And you can't get help unlocking your device. Anyone that facilitates unlocking of cell phones is themselves violating the Digital Millennium Copyright Act anti-circumvention provisions. So, though I think we agree that customers shouldn't be able to unlock their device in a way that breaks the contract, the remedy, if they do so, should be that early termination fee or whatever other remedy is specified in the agreement with their carrier. If you move overseas, there's no reason you shouldn't be able to unlock your phone and pay the ETF. Doing so should not violate federal law, whether it's on the civil side or the criminal side.
We're in a jargon-free zone here. So ETF is an early termination
Right.
fee. And you use another big word there, which is the anti-circumvention provisions. Jerry, do you want to just maybe take us back to the 90s just for a moment here? And And I was trying to think of a clever musical reference to go along with Blondie and Carly Rae, but 1996 failed me. But tell us, so DMCA, anti-circumvention, what's that about?
Well, I mean, so I think this is what the commissioner was getting at with his Blondie reference. You know, if you have a digital file or digital content, which after all, we're talking about copyright here, and it is content that can be copyrighted, whether it is music or, you know, or words or video, it's what's copyrighted. Now, it's difficult sometimes to enforce copyright when it's so easy to infringe, right? When it's so easy to copy files, when you have the easy dissemination, replication of content files on the internet, it's very easy to breach. So what Congress did with the DMCA is say, look, content creators, you can put a digital lock around your content. And if somebody unlocks that lock, that is a crime. That is a violation of the law itself. So that's what the DMCA is about. When it comes to cell phones, it's not clear to me what is the content that is being protected. You're not trying, so I mean, if you ask, what some will say is, well, it's the software that runs on the cell phone that is being protected by the digital lock that you have to unlock. But that's just strange. When Americans, overwhelmingly in the petition that we saw, over 100,000 Americans ask for the right to unlock their cell phones. They're not asking for the right to unlock their cell phones in order to make copies of the firmware on their phones. No, they're just asking for the right to unlock in order to take it to a different carrier. That's very different from what the DMCA was intended to do. And if I could just say, address something that Larry brought up, I totally agree that that it's good to have different choices for consumers in the market, including a subsidized phone option, right? So you can have an option where you buy an unlocked phone for, say, an iPhone is probably about $600, $700 if you just buy it unlocked. You can take it anywhere. Or you can buy it for $200 or $100 if you make a promise to stay with your carrier for 2 years. That's a subsidized model. But there's no reason why that choice between subsidized and unsubsidized can't exist with simply a contract regime. There's no reason why you need the DMCA. As Ryan was mentioning, you make that promise, you sign that contract, and you're bound for those 2 years, whether you unlock the phone or not. If you unlock the phone and go to another carrier, let's say you're on Verizon, you unlock the phone, you go to AT&T, Verizon's still going to keep sending you the bill.
That can't happen. Why definitely? Because Verizon operates a CDMA network and AT&T operates a GSM network.
Well, I'm using that for
Okay.
for the
But
purpose
that's
of
really,
illustration.
okay. But
Okay,
it's-
well, the fact that, okay, so if you move to France, and
Okay,
you take your
fine.
GSM phone to France, Verizon's still gonna keep sending you the bill. They don't care that you moved to France. And so, and they're gonna enforce that contract, against you, and that can happen through, either an efficient breach, as Ryan said, or some other remedy.
Before you jump in here, Larry, of course, there are networks in the U.S. that are compatible. So let's just take those examples to make this simple, and let's say that I'm switching from AT&T to T-Mobile.
Mm-hmm.
So what's the problem? Why shouldn't I be able to unlock the phone?
Prior to the end of the contract?
Yeah. So let's say either that I want to end my contract and I want to pay the early termination fee or whatever else the penalty might be, or I want to simply stay on the contract, but I want to unlock the phone when I take it overseas, or in the third example, my contract has expired.
Right. Well, each one is sort of separate. I mean, I think if you were to call up, you're an AT&T subscriber, I mean, I can't speak for AT&T, but if you say I want to go to Europe, I have heard anecdotally that they'll go, okay, well, if you're a long-time subscriber, I don't think that's that big of a deal. If you want to pay the early termination fee and get out, I don't see a problem with that. I mean, the question is in terms of bringing copyright, one can certainly make a legitimate argument, and I'm not unsympathetic to it, that, why are we dealing with copyright in terms of handset unlocking? To me, I don't approach it, and then, there is a fix that's going to be in there, and I think Commissioner Pai is probably right, and, we can put this mess in terms of cell phone unlocking behind that. My view on cell phone unlocking is that the copyright is sort of incidental to the overall desire of basically getting an unlocked phone at a subsidized price. And that's what this issue is all about. It's not having anything to do with copyright. I think people are using copyright. When the registrar came out with its copyright decision a couple months ago, people had not sort of focused on the unlocking issue, and it became sort of a cause célèbre. But for those of us who have been doing this a long time, back in 2007, again, I encourage you to revisit the entire wireless Carter phone issue. This is all about trying to get subsidized phone, an unlocked phone at a subsidized price, and that's what people are very upset about.
Let's unpack that, but Chris, is that a fair characterization?
I think that, it's important to note that, when the Copyright Office first created the exemption, this was back in 2006, there were already entrepreneurs and individuals who were unlocking their phones and being sent notices, DMCA notices that they were in violation at that time. So, I don't know that the intention was to protect a certain, and I don't think the intention should be to protect a certain business model with subsidized phones. Now, that being said, I just find it hard to understand why the idea of unlocking a phone and having subsidized cell phone service can't be compatible together. Consumers should have a choice of whether or not they want to, when their contract ends or when they want to get out of the contract with an ETA, they should be able to make that choice. But there's also no reason why they can't, look to actually sell their phone or keep their phone or move it to another network. To me, this issue is really about the ownership of a device, and if consumers should have the option to own a device and use the things that they purchase how they like. So, the right to unlock doesn't change the contract rights. I think that's the points a lot of folks on the panel have been making, and in fact, it gives consumers greater choices. If a consumer, for example, enters a contract with AT&T and they pay $200 for their iPhone, a year later, maybe they don't like AT&T's service. I'm not trying to say anything bad about AT&T, but a consumer has a right to change their mind, and so taking advantage of an early termination fee and switching to another carrier is within their rights under contracts and also under their rights as an owner of a device. And so, opening up a marketplace for tools and services that allow ordinary customer to unlock their cell phone just seems like common sense to most consumers when they've actually spent money to buy and own a device.
So, Larry, since we've sort of stacked the panel slightly against you, let me jump in here in your defense.
Just a little bit.
Let me jump in here in your defense and say that I actually very much agree with you that there is a larger current here of people trying to turn this into a conversation about subsidization of phones. And for some people, and Chris alluded to this, for some people this is about broader issues, like as Chris said, you should own your phone, period, full stop. And it's certainly true that in 2006, 2007, 2008, there was quite a scandal, or at least quite a controversy about the initial launch of the iPhone. And you're quite right, and you've done some great research showing that actually the subsidies that launch phones are not only make the phones cheaper, but actually help to ensure that innovative devices like the iPhone get launched in the first place. And in fact, contrary to the assumption that some people made, it wasn't AT&T that insisted on an exclusive and subsidies. It was actually Apple. So I'm all with you on defending exclusivity as something that actually is very good for consumers, even though it may not seem that way. And some people may think that they'd be better off buying fully unsubsidized devices.
And speaking, by the way, the ETFs, let's also not forget that the government, particularly during this administration, has pushed very hard to get those early termination fees prorated. Okay, so this notion that I can pay the prorate, well, after about 18 months, you pretty much almost have a zero ETF. So that's, this is a method of contract enforcement. I mean, by way of analogy, it's not completely accurate. If I want to go buy a car and it's self-financed, for example, I take a pledge, the GMAC takes a pledge on my car. I don't pay, the car is actually gone and it's repossessed. Well, nobody's going to do that for a handset. You're trying to find ways to mitigate in the market, and it's not, we hear about individual people. I mean, what this is really about is sort of developing, the black market, taking these phones, paying the ETF fees. I mean, I could construct a mathematical example where it's still worth it to go buy the phone, pay the ETF, and still walk away, and then sell these around the rest of the world, which is what happens. So I think the overall copyright enforcement, I mean, I have no problem with the fix that, Commissioner Pai has proposed in the legislation. I mean, we shouldn't be revisiting these things because it's just not worth the agita, I think, of going through this every 3 years. But that, and that's why I said you got to parse out the difference between the question of whether we should subsidize handsets and pay for that versus copyright enforcement, which is a completely separable issue.
I guess I'm just curious if the contract is currently written, it's profitable to pay the early termination fee and resell it.
Right.
First of all, if you're doing that and the carrier is getting, what it expects to get, at a profit or however you want to define that, and the person's taking it, reselling it overseas, I don't see a problem with that. But just out of curiosity, why not write the contracts in a way where the penalty is higher than buying an unlocked phone would be? Why
That
not?
could be an option.
Okay, and that's totally done within contract, and you don't need the DMCA.
I mean, you're saying, well, again, I'm trying to separate the issue of hands-on unlocking versus DMC
And right.
enforcement.
And I think everybody on this panel, agrees that we don't want to subvert contract law.
Right.
Absolutely, yeah.
And to Larry's point about people that are buying phones and selling them in a way that is profitable, that is a problem. A track phone, for instance, has a business model whereby they sell phones that are subsidized and locked to their network. The buyers do not contractually promise to stay on track phone. However, the devices are locked, so the track phone expects that people will stay on their network. But some resellers are buying up track phones in bulk, in cash, unlocking them, and then selling them. And I agree that this is a problem. The question, however, is whether we need the DMCA and whether we need the DMCA in this context. We certainly need the law, or some aspects of it in many other contexts. But if you look to the cases where TracFone has actually sued resellers, there's a laundry list of claims on which TracFone has prevailed that would make any litigator happy. Unfair competition, false advertising, tortious interference, trademark violation, unfair competition, violation of the Lanham Act, and so forth. So if indeed this is happening, companies like TracFone should have remedies. But I see no reason why the remedies that exist outside of the Digital Millennium Copyright Act are not sufficient.
Do you disagree? Why should legislation, whether it's copyright or the sort of interference you were alluding to about the administration and the FCC trying to discourage early termination fees or trying to encourage that they be prorated, why should the government interfere with any of this? Why can't, as Commissioner Pai said, why can't wireless companies sort out whatever arrangement makes sense in terms of an early termination fee or whatever other penalty there might be under a contract?
Let's take the world we live in, not the world we'd like. I mean, it is what it is. But as I'm listening to the conversation, I mean, you're asking, talking about this from a policy perspective, you're asking some fundamental questions here. Okay, so the first question is, I keep going back to this, but I think we have to view the debate in this context. I mean, the first question is hands-on unlocking a good idea or a bad idea? Then the second question is, I keep going back to this, is, was the registrar's decision correct or not? Under the reading of the law, sure it is, but do we want that as a society bad idea? Then the third issue, and this is what I'm picking up on the panel, is, do we need the DMCA at all or not? Okay, and you're talking about a very, very important law. You're talking about a very complex issue. I spent my Father's Day weekend curled up with Jerry's book this weekend. I paid for it lawfully. Paid for it lawfully. So, and these issues are with the internet and technology, where your cost of duplication is zero. Okay, we're asking, is the DMC required? Well, that's a very loaded question in and of itself as well, that you have to sort of think about, because as I was reading through your book and the essays,
Talk copyright on balance?
what? Go ahead, plug. Okay, good. So and what I picked up, you sort of had sort of two schools of thought, I thought, in your book, which was, the first one was, well, copyright isn't really a full right, and so it's sort of squishy, we don't deal with it. And then the second one is, it's a victimless crime, and, do we want to make copyright criminal at all, which is the stuff, everybody keeps, having been involved in this debate for a long time, every time I keep getting on one of these panels, somebody says, the guys in the black helicopters are going to swoop down and then arrest my mother for unlocking her phone. And, what we're talking about here broadly with copyright, and I think, moving off the handset issue for a moment, is that it is not costless. We have copyright to protect works of intellectual property. And, there's a lot of debate about that, but I use an example of a movie, tremendous sunk cost. Supply slopes upward. So if we don't have a way we want more output, we need more revenue. And these are the battles that we are talking about, because this whole copyright debate keeps coming back in my mind to what is the appropriate enforcement mechanism. Some people say it's victimless or the cost of compliance, but there are costs involved, and I think that's where we need to be starting to focus the conversation.
Let me remind you that this is about unlocking and not about the entire copyright debate. We did have that event last year, and it's up on our website. Jerry and Ryan were both there, and you can read Jerry's book, Copyright in the Balance, if you want more information on that. Copyright Unbalanced, excuse me. And one might fairly say that the book is a little unbalanced, fairly. Certainly, there are people here who believe in copyright, who actually think that copyright shouldn't apply to unlocking, and that that the larger debate about copyright shouldn't really be the issue here. So before we get into the larger context of the DMCA, Jerry, do you want to? And I apologize for the slide on your book. It's a great book. I just think there's a lot to be said for copyright. And actually, as somebody who believes in copyright, I think one of the issues that never gets talked about is that copyright, at the end of the day, is something that works only if we all respect it, and that criminalizing something like cell phone unlocking, even if Larry's right that it's been exaggerated exactly what the practical effect of the Librarian of Copyright's decision will be, criminalizing copyright helps people villainize the system. And I think it certainly helps to demonize a system that is really great for artists and content creators. So again, I'm somebody who thinks that the librarian's gone way too far here. But do you want to respond to Larry?
Just briefly, I hope that when you said that the book was unbalanced, what you mean is that it presented one side of the perspective, which is fine, because that's what the book was meant to do, is present one side. I don't think that the book says anywhere that I saw that copyright infringement is a victimless crime or anything of the like. I think what the book says is that you do have costs to infringement. At the same time, there are also costs of over regulation, where you can go too far in. Take for example, burglary. We can get rid of burglary if we had the death penalty. We don't do that, however. We see a sense of proportionality because the costs would be too high. And what we need to do is strike the right balance. So I believe in property rights. I believe that copyright is a property right that should be protected. But I do think that we've gone in some cases, for example, cell phone unlocking, we've gone too far. And so we get unintended consequences as a result. And what we need is a balance. That's why the book is called Copyright Unbalanced. We need to just strike that balance better, and maybe unlocking is one place to start.
If I could add to that. Oh, sorry. Go ahead, Barry.
No, I was going to turn it over to you.
Yeah, no, because I really agree with Jerry, and I just want to add that, the broader discussion of unlocking, not just with handsets, but devices and technology generally, is a really important one for us to have, and actually I think I'm hopeful that the Congress will have it in the future as they start to look at broader copyright reform. But the reason that is because, with the world we live in with digital media and new technology, you can put a technological protection measure, a TPM, which is what is the lock that's discussed in the DMCA. You can put TPM on just about anything these days. And so it really gets at, what does it mean to own something in a digital age? I think probably one of the best examples out there right now is with cars. Cars are pretty much computers on wheels these days. And you will find TPM in your car. Now, if you want to change your oil in the car that you bought and owned, you should be able to do that. But with a car these days, you have a light that tells you that your oil is low, and sometimes you can't turn that light off unless you have the codes to circumvent that lock on your car. There are a number of things now, and probably a number of things in the future where we will see manufacturers putting locks and TPM on devices, and it's important that we look at them, just as we look at cell phone unlocking right now, and we see if it's worthwhile to create exemptions for them. I would say that, for someone to be able to change the oil in the car that they just bought is a common sense fix, and there's others out there. So I don't think, I don't know if Jerry's asking for this, but I know we're certainly not asking that you eliminate copyright law totally. We're just asking for targeted fixes that allow you to update the law and balance the law for new technological uses.
So Ryan, how do we distinguish the unlocking issue from the larger debate about anti-circumvention?
You can't download a car on BitTorrent, or a cell phone for that matter.
You can 3D print it.
Well,
Someday soon.
That'll be the next panel. But there's this distinction that is very important between content, expressive works that are what economists call non-rivalrous, where you can duplicate them at zero or at minimal cost, and on the other hand, devices where you have an agreement with a company, a seller, a car manufacturer, or a wireless carrier. Congress needs to, and I think is thinking about, how to ensure that the anti-circumvention provisions of the Digital Millennium Copyright Act go to the issue of preventing the unauthorized copying and reproduction of expressive works, which is in many cases a real problem and is seriously harmful, and distinguishing that from situations like the car or the cell phone. Right now, the House Judiciary Committee under Chairman Goodlatte is taking a very careful and close look at copyright reform. I'm sure that anti-circumvention will be part of the hearings that will come up in the remaining session of Congress. The notion that we may not think the DMCA ought to apply in the context of cell phone unlocking does not mean necessarily that all anti-circumvention provisions are bad. It may mean that they need to be tweaked in a way that permits some types of circumvention in the context of cars, perhaps, but not in other contexts. Now, striking that balance in the statute is very difficult. There are unintended consequences. Simply because you can circumvent technology for fair use could mean that you can circumvent it for infringing purposes. So there's a big debate that Congress needs to have, but that can happen over the course of the next few years, whereas today Congress can address the narrow issue of cell phone unlocking, as Commissioner Pai explained, without getting into the very sticky wicket that is DMCA reform.
Okay, so let's talk brass tacks about fixing the problem. So Ryan, when you just said that, are you saying that you think that the immediate issue of cell phone, or for that matter tablet unlocking, should be dealt with legislatively, and we should deal with the larger problems of how the DMCA works later?
Yes.
What does everyone else think?
I think the answer is yes, but if you look at the laws, the bills that have been introduced so far, some of them do not give you that permanent fix that Commissioner Pai was talking about. So just overturning the decision of the Copyright Office, but kicking the can down the road, as he said, to 3 years from now, and allowing them to revisit that decision does not give us that permanent fix on cell phone.
So you want to make sure that whatever happens, the Copyright Office can't, the Librarian of Congress can't simply reverse whatever Congress might do legislatively today?
Well, I would say that, on the cell phone unlocking issue itself, there's no reason when there's this sort of bipartisan consensus that we shouldn't be able to have some sort of exemption written into the DMCA for mobile devices. That's permanent.
Including tablets?
Correct.
Jerry?
So I agree with that, except I think there's probably a more elegant way to do it. I think when you write in, with all apologies to Commissioner Pai, when you write into law, wireless devices should be able to be unlocked so you can go to a different communications network. That includes definitions for what is a wireless network, or what is a wireless device, what is a communications network. What about devices that maybe it's your car with your oil change or something. That's not a wireless device. I think Representative Zoe Lofgren has a really elegant way of doing it in her bill, where she says, circumventing a lock is a crime if it is done in order to breach copyright. That makes sense. That's the purpose of the DMCA. And you don't have to define wireless devices or anything. Unlock your phone in order to take it to a different communications network, or your tablet, or your car. That's A-okay, because you're not trying to infringe copyright.
So Larry, what do you think about those options? What could you live with?
Well, I'll tell you what I can't live with. It's probably a better thing. I mean, I think Jerry raises a very, very good point. on definitional problems, and as lawyers that we all know how one can fall into that trap. I mean, it's interesting. I have a copy of the Goodlatte bill, and then I have a copy of Senator Klobuchar's bill, and the two take a very different approach. And I think it highlights a lot of the stuff we're talking about on the panel. Because you got the Goodlatte bill, it says, well, we're going to just repeal the most recent ruling and then have a rulemaking, and then let's try to put this to bed. And everybody seems to be generally on support of that. I mean, is it as elegant as Jerry would say? Perhaps not, but it seems to work. But going back to we were talking about contract rights, I would commend people to look at Senator Klobuchar's bill, which is co-sponsored with Senator Lee and Senator Blumenthal, where it says it gets the FCC involved. It says the FCC, not later than 180 days from that, shall direct providers of commercial mobile services and commercial mobile data services to permit the subscribers of such services or the agent subscribers to unlock the type of device used to access such services. So in other words, we're talking about using contract as a right, and if you were to take the Klobuchar bill that essentially eviscerates the whole use of contract, you're saying, by the way, sign a contract, but any form of enforcement is gone. So again, there's different approaches to this, and we need to parse this out.
You want to make sure the FCC isn't put in charge, and you also want to make sure that we respect private contracts.
Absolutely. I think the contract right that's where this whole thing is. You're trying to find some mechanism to minimize theft and free riding.
So we at Tech Freedom, we talk a lot about, again, Richard Epstein's concept of having simple rules for a complex world. So one way of paraphrasing what you just said is that we don't want to take rules that are already complex and make them even more complex by layering on more exceptions and special circumstances. So to the point that Jerry in particular was raising, how do we write a simple rule that will actually hold up when we're talking about unlocking lots of other sorts of devices, keeping in mind that there may be anti-circumvention tools that still should be covered by the DMCA, or at least that's a separate issue. And that what we're really talking about here today is unlocking for interoperability purposes and for other purposes that we've all agree users should be able to pursue, and that actually are consistent with the goals of copyright, which is promoting innovation and creativity. So how do we write that simple standard? Jerry, you already alluded to that, and Chris?
Again, I like the approach that Representative Lofgren takes. You basically say the predicate here is copyright infringement. After all, that's the point of the DMCA. If you're circumventing a lock in order to infringe, okay, that's a problem. But if you're circumventing a lock for a lawful purpose, such as increasing the font size because you can't see very well, you want to change the oil in your car yourself and then turn off the light, these are lawful purposes. So it's a very simple, elegant way to do it.
I'd agree with Jerry. I think you should be able to write a law like the Lofgren bill, which we support, which allows for general unlocking for non-infringing purposes. And that should be extended to not just the individual, but the individual's agent or someone who is offering a service that helps them to do that, so that you don't have to be a software engineer or a programmer in order to unlock your phone, unlock your car, get access to ebooks. Without that sort of law, I think it becomes much more complicated. If we're stuck with just the triennial review process at the Copyright Office for exemptions, there are many things that could be fixed with that. The idea that, for example, each review every 3 years is a de novo review and doesn't take into account previous decisions by the Copyright Office probably harmed the cell phone unlocking exemption when it came up in 2012. When an exemption has been there for several years, 2006, 2009, and all of a sudden 2012 it goes away, that sort of regular review can cause innovators not to want to create services and tools that allow you to unlock if they think that those will suddenly be outlawed in 3 years.
If the cost of enforcing the anti-circumvention provisions of the Digital Millennium Copyright Act were zero, that is, if we could make sure that everyone who circumvents to infringe is punished, and everyone who circumvents for non-infringing purposes isn't, I think the Lofgren bill would be a no-brainer. But I have some reservations about it because of the fact that enforcement costs are, of course, very high. What if a company invests to develop a service that circumvents the DRM of, say, a Hulu or a Netflix or a streaming platform to allow users to extract a 30-second segment of online video for fair use if the user certifies that they're going to use that chunk in a transformative manner. That would presumably be non-infringing, both the development and the distribution and the use. But then let's say other actors come along and repurpose that. They take the source code. They somehow reverse engineer the platform, and they build upon the investment in circumvention to make a tool that actually can be used for circumvention. The point is the distinguishing between circumvention of content protection, TPMs, technological protection measures that actually do protect expressive works, as opposed to, say, cars. Protecting that content creates real challenges when circumvention can occur for non-infringing purposes. One solution to that, of course, is that the owner of the content actually enables users to make fair uses so that there is no need in the first place for anyone to come up with circumvention, because there are already ways to make fair use. But we shouldn't, I don't think we should embrace the Lochran approach to open arms until we think more carefully about the costs of distinguishing between circumvention technologies.
To that real quick. Going from a policy idea to a rule is a very difficult thing. I know lots of policy ideas I'd like. Turning into a rule without unintended consequences is another matter. And I think what we have to understand that as we start to craft legislation, whatever it is, if we were going to go that route, firms are not passive recipients of regulation. Okay, as soon as people know what rules there are, people want to exploit the rules, they will. The idea of a triennial review seemed like a good idea at the time. Perhaps that was too short of time, who knows? But I think we have to be exceedingly careful in this space as we start to tread here.
Well, there's just a good question on Twitter here for Ryan. When the lawful purpose is fair use, how does the standard apply, given how difficult an analysis fair use is? In your example, you talked about users certifying in that tool that they were that what they were doing was fair use. How would you respond to content owners who would be concerned that the line might be drawn here in such a way as to open the door to circumvention tools?
I would respond that that's a fair point, and that's a reason that we should be careful about writing a law that exempts fair use for infringing purposes. Really, I think this may well come down to a balancing, a weighing of, on the one hand, is fair use important? Is circumvention stopping it? And on the other, to what extent do the anti-circumvention provisions prevent infringement? Now, when you look at the internet, you can get a bit perfect copy of every Blu-ray the day it comes out, despite the Digital Millennium Copyright Act. So on the margin, what does the law do to protect that content? The answer is relatively little. But that's not the case in the future, or that may not be the case as we move toward a model where people are accessing content on the internet. Perhaps the ease with which infringers circumvent DRM will decrease. Perhaps the law will do more to prevent infringement in the future, and these are all things that I think Congress needs to consider. There is, of course, this debate, the basic standard that in the Sony case, that if a technology has substantial non-infringing purposes, it's lawful. And perhaps that's the ideal standard. It's not a question to which I have a good answer, but it's a difficult one that requires a lot of tough empirical questions.
Okay, so are you all in agreement then that as a procedural matter, we shouldn't be repeating the process that the Librarian of Congress has gone through in the past? Which is to say, not just the fact that it issues exemptions every 3 years and then reviews them every 3 years, but that there is this 5-part test that any advocate of an exemption has to satisfy. And if they fail to meet that burden, the exemption disappears or is never granted in the first place, as in the case of tablets. Larry?
Earlier, I'll actually defend the librarian. It was an open notice proceeding. They adhered to the law. They deliberately did not politicize it by turning it into a popularity contest at the White House. If you read the law, one could certainly argue that there is almost a presumption of exemptions rather than of circumvention. Do people like having to go in every 3 years? Probably not, and that's it's an issue that we can discuss. But I think the process is what it is because it has worked so far. Perhaps not perfectly, but that is the system that we have today.
I think I'd say that you're absolutely right. The librarian I think, did a good job following the process that is in place. And there's no reason to criticize the determination on the merits in the sense that, he was working within that framework. But that doesn't mean that, that given the outcome and given, and sort of the outcome as a last straw in a long series of determinations, that we can't decide as a country that we don't want that process anymore. And I think that's what we're saying here. It's a process where, every 3 years, people who have poor eyesight have to go and request permission to use their devices in a way that makes it so that they can read them. We shouldn't be doing that.
So let's talk about presumptions here, and then let's try to move into the bigger picture here. So it seems to me what you're getting at is, the general rule of Anglo-Saxon law is that which is not prohibited, that you're free to do anything that is not prohibited, right? And the opposite is true in certain continental legal systems where you are essentially free to do only what the law permits you to do. And Jerry, what you just said is that the DMCA, and I think quite fairly, the DMCA is essentially, in that sense, it's a profoundly un-American presumption that you're only free to do what the law permits you to do. Now, it exists for a reason. I mean, there was, Congress was concerned quite legitimately about circumvention of technological protection measures. So without regard to the specifics here, how do we deal with that problem? How do we craft a rule that both adapts better to new technologies and doesn't force innovators and users to go running to Washington for permission to do something innovative?
It better myself, the way you described it. This is a system where you have to get permission before you can do something. How do you craft that rule? I think you focus on what the purpose of the DMCA has always been, which is to address copyright infringement, address mass copyright infringement, allow content creators, as Ryan keeps emphasizing, to protect their works, and so make copyright infringement a predicate for anything else related to the DMCA. You don't make it a case-by-case determination that this use is allowed, this use is not. Make it any use is allowed as long as it's not related to or not infringing copyright.
So under that proposal, there would no longer need to be an exemption process because you wouldn't be in the business of granting exemptions. You would just say, my technology doesn't infringe copyrights and therefore it's not covered?
And the burden of proof would be on the person who's alleging that you are using the technology in order to infringe copyright.
So do you think that the companies developing those technologies might actually lack some certainty? In other words, today, as bad as the process might be, today it's really clear whether you got an exemption or not, whereas in the scenario you're describing, it wouldn't be clear. The burden would be on someone to say that your technology was infringing until proven otherwise, or at least that it was circumvention technology. But do you think that there's a need for some sort of certification or an advisory letter or some process to, if an innovator is uncertain, to actually get clarification that in fact their technology isn't a circumvention tool prohibited by the DMCA?
No, I
That was a
don't
rhetorical question.
Yeah, I don't like regulatory approaches where you have to get permission from a regulator before you can do something. I'd rather see a common law approach where you try things and then you experiment in the marketplace, and if something doesn't work out, you can solve that through a common law process. Chris, do you have a?
I'm just going to add, I get concerned when folks talk about outlawing technology or forcing technology to prove that it's not infringing. Before we had a digital age, we had Xerox machines. Xerox machines could copy any sort of copyrighted book that you wanted. No one ever expected, or no reasonable person expected that you're going to outlaw a Xerox machine just because it can copy a book. The hard part, and I think this is the point you're getting at, the hard part is how do you, in a digital age, deal with technology that can rapidly copy something over and over again and make almost perfect copies. Now that's a hard question. That's a different question. But I think we need to, as we look for that balance in the law, we need to try and find a way not to outlaw the technology that brings about all these new innovative uses. I think the point about folks who can't read a device, or I often use the example of reading an ebook if you're blind. The ability to circumvent a lock in order to allow an app to let someone read when all digital media is going towards digital books and fewer paper books is something that we need to make sure is there, and that's part of that balance. And yes, I don't know if I have the exact answer of how you protect folks from those repeated, easy, perfect digital copies, but that's the sort of discussion we need to be having instead of outlawing specific technology.
And to summarize, you're both, I think, implicitly saying that a distinction can be made between allowing users to unlock their devices for the purposes we've been talking about today, to customize them for lawful purposes, to change them to a different carrier on the one hand, and on the other hand, the sort of example that Ryan gave of breaking a technological protection measure in such a way as to start infringing actual copyrights. You think that there's a principled way to draw that line?
Absolutely. I think you can make a determination of whether a lock was circumvented, and you can make a copyright determination, a court could make a copyright determination about whether what you were doing after you circumvented was infringement or not. So that's, that's a determination that a court could make. And I would say to Ryan's earlier point, you could end up with the world where if you accept a case-by-case determinations where the folks who would make non-infringing uses of a circumvention technology would end up not being able to do it because they're trying to do the right thing. But the criminals who are trying to rip the Netflix stream are still going to do that.
So, Larry, what do you think about the practical implications of this kind of revision?
To be honest, I haven't really thought it through, but as I'm listening to the conversation, the one thing that just popped in my head was patent trolls. And if we adopt that model, then all of a sudden we have technology, and all of a sudden you're being sued out of nowhere, being greenmailed, because you're using my technology, you're infringing, I had no idea. And all of a sudden we're clogged, and that's the whole, the problem with our patent system. I'm not sure what the answer is. It's extreme. I mean, we have a system, we've thought it through a lot. We've made a societal judgment that protecting IP is a good idea and starting with that presumption. Some people may disagree with it, but you've got to start somewhere, and I think having the presumption that we have now, which is, here's the technology, let's prove the exceptions, for better or for worse, seems to be working. Are there problems? Yeah. Can we deal with them? Sure. I mean, I've got a draft bill right here. So, no law is perfect, and there's always the laws of unintended consequences anytime you put up a rule, whether it's, and I was talking about this with my partner before I came here, and what I'm reminded of, believe it, is a great example is net neutrality. Here's a rule that everybody thought was a great idea and has all these unintended consequences. And going back to my point earlier, where firms are not passive recipients of regulation, they're going to do what they do. If you own intellectual property, you are not going to sit by and let your intellectual property be stolen. You are going to do actions. You might vertically integrate, you might stop innovating. I mean, it's not a perfect world, and we have to think very, very carefully about what we're doing.
What tech policy event would be complete without someone referencing net neutrality? Just like at any other event, it's normally copyright that comes up and crowds out net neutrality. They're always in competition. I'm going to let Ryan have the last word. I'm going to ask one more question, and I'm going to turn to the audience.
We've had 15 years since the Digital Millennium Copyright Act's enactment, and we need to look at the history of those 15 years and look to the future. What role is digital rights management going to play? Is there a need for Congress to revisit this law? There are certainly arguments to be made in favor of it. Of course, there are also problems if we go down the road of making it easier to develop technologies that facilitate infringement. The current presumption certainly reduces the amount of circumvention that occurs. Whether it does so in a way that is worth the costs is a tough question that Congress is thinking about, fortunately.
Okay, so this is my last question. So Congress is thinking about, right? Just think about that sentence just for a moment, right? As Margaret Thatcher said, there is no such thing as society. There are individuals and families. There's no such thing as Congress. There are individual members of Congress, and there are their staffers, and they have a hard job. It's easy to laugh, but they're faced with a lot of issues. And to Larry's point that he raised earlier about We all have ideal policies we want to see put in place. How do we make sure they actually come through the ringer the right way? I have to say, I think I disagree with Larry on where we'd come out here. I am very sympathetic to his concerns about the way that this issue is being used, in the sense that there's certainly a broad sentiment in the internet policy community that they stopped SOPA, they helped to derail CISPA, and we were part of both of those efforts. But there's a sense now that they can do anything. If they just get enough people to sign petitions, they can get something done. And the question is what that thing is and what it looks like. And I think all of you agree that this is a genuinely difficult issue. It might be a fairly simple matter to say that mobile devices shouldn't be covered by the DMCA. But the question we've been talking about how you either change the current process or how you write a simple fix to govern what the DMCA should cover in the future, how you draw that line, it is a genuinely difficult issue. So my question to all of you is, what do you think that this issue and the way that it's been covered and the way people talk about it and the way that they may indeed try to bring in other issues like whether cell phones should be subsidized, what do you think it says about tech policy and the ability of Congress to get hard issues like this right by writing, again, simple rules for the future, and even more so than what it says about Congress, about what it says about how people who are starting to care about technology policy, how they intersect with Congress. Do you think that we're going in a good direction towards writing better rules, or are the rules going to be worse in the future? And let's just go down the panel. Ryan?
Well, as someone who agreed with the principles underlying Barron's examples of SOPA and CISPA, but disagreed with the way in which they were implemented, it's a good question. With all of these internet activists who were very vocal and signing petitions in mass numbers, are they going to contribute positively to the debate? If they are willing to appreciate the complexity of these issues, perhaps the answer is yes. So far, for instance, the cell phone unlocking push has been positive, but as the copyright issue proceeds, it's often too easy to get confused about what's actually good for consumers. Larry's points about interoperability are correct. Mandate that every U.S. carrier use the same technology and the same network might sound great to many consumers and internet activists, but would in fact probably be a very bad idea. So hopefully those of us who spend all of our time working on these issues can do more to guide them in a direction that will promote positive policy change.
And then are you more or less optimistic now about getting laws right?
More optimistic.
Chris?
The short answer is I'm also more optimistic. The longer answer is, public knowledge was with you guys in opposing SOPA, and I'm a firm believer in the idea that the people get the government that they demand. And so when you have a Congress that is made up of average citizens, and they, like most average citizens, have a certain baseline, low-level understanding of how technology works, it's so important that they take the time to have experts at the table, all stakeholders at the table, and that a process in determining laws around technology are done deliberately. That wasn't the case with SOPA. I caution against demonizing. I don't know if you were trying to purposefully or not, but if I caution demonizing the petition efforts, because this is.
I certainly wasn't.
Okay. I appreciate that, because I think the petition on cell phone unlocking and other petitions around technology issues are one of the great ways in which average Americans have been able to have their voice heard on an issue that's complicated and difficult for people to understand. When they get something right away, and I think cell phone unlocking has been something that people have gotten right away because everyone has one. It's just an enormously important tool that, of course, is protected by the Constitution. So I embrace it, and I think it's a great addition that the White House has had to create the We the People petition process. But I would say, moving forward, it is hard to make proactive, positive policy rather than to stop bad laws. And so it's important that Congress continues to have all stakeholders at the table and that they have long deliberative discussions about cell phone unlocking and other broader copyright reforms. It's a difficult topic, and I think it's difficult for members of Congress to weed through the technology and the engineering and the law without having that time and that input.
Let me just put my question more simply to Jerry and Larry, which is, petitions are great at getting Congress excited about something and creating a sense of urgency, but what happens when the sense of urgency is created about a genuinely hard topic that there isn't a lot of attention span here for? How do you, what does the process look like to make sure that Congress gets the law right?
I don't think there's any. It's a process that we know and love. It's Congress being Congress. What I am optimistic about, though, is, I'm especially optimistic about copyright, and this is ultimately the copyright issue that we're talking about here. And the reason for that is that for about a century, the way the copyright law has been fashioned in this country, it has been a negotiation between the content makers and owners and broadcasters and other interests, like librarians, literally sitting down negotiating a copyright law that Congress then gives a thumbs up to. And that's worked for a long time before the internet, right? But before you could have this kind of demand on content. But now, for the first time, because of the internet, I see the public having a seat at the table that it's never had before. And so for that reason, I'm optimistic. I think that's a reason we saw SOPA fail. And I think that's a reason why, for the first time in ever that I know of, a registrar of copyright has suggested reducing the terms of copyright. Because we've had this negotiated lawmaking for such a long time in the copyright space, we've ended up with copyright unbalanced. And so now that the public is involved, I think we can fix that unbalance.
Having public engagement is always a good thing. I can tell being a former staff attorney, the only person probably in this room has been both the GS1 and the GS15 before the age of 33. It's my great professional accomplishment. The problem is, the work that we do, you can be as technical as you want. If you read the Phoenix Center's work, we've got 4 PhD economists on staff, and we publish in referee journals. And we stare at these things, and we model these things, and we try to figure it out. But this is a political process, and by definition, I'll give you a great quick anecdote. During the SOPA-PIPA debate, I noticed my daughter's Facebook, she had changed her Facebook page. It said, "Stop SOPA." So I scream out, said, "Get in here. What is that?" She goes, "Well, they're going to shut down the internet." I said, "Well, who told you that?" Facebook and Google. I said, "Would you like to read the bill?" "What's that?" Gave her the bill. She goes to her room, goes back 5 minutes later. I took it down. That's public engagement. And so, look, I've been doing this business a long time, and, as I like to joke, look, when you're talking about laws and sausages, you're never going to make things right. I think all of us who are serious about policy is that we try to make things as not wrong as possible and be happy with that result. But it is important to be engaged. It's important to take these issues seriously. And the more we can have conferences like this and try to bring that to the fore, I appreciate it.
Speaking of engagement, I'd like to take questions from the audience, and I'll field some on Twitter, too, if anybody has one. My colleague Will Reinhardt has the mic. Don't be shy. I'm sure somebody has a question. I think I see a question in the back. And please make sure to identify yourself.
Hi, I'm Peter Van Valkenburg. I'm actually here with Tech Freedom for the summer. I'm a Google Fellow. Great panel. My question is, effectively, if we go with the Lofgren plan, which is a little like the Chamberlain v. Skylink decision in the Federal Circuit, i.e. you need a nexus between a copyright infringement and an act of circumvention for it to be actually a violation of the DMCA, at that point, what does the DMCA do as far as its circumvention provisions at all, and why do we need them? If we could just get to that through copyright, other than you broke a lock and as well as intruding. In that sense, the willful provisions of the Copyright Act would probably get at that and elevate damages instead of the DMCA.
You can imagine situations where you have an unlocking mechanism that serves no other purpose than infringement. I think Ryan was sort of alluding to those, and those would remain illegal.
Anyone else? Any other questions on Twitter? Anyone? I'll exercise that, although I've been asking a lot of questions, I'll exercise the moderator's prerogative and just ask one final question here. So, Jerry, you alluded to there's another provision that's ongoing, or excuse me, another proceeding that's ongoing now about revising copyright law. Can you give us a little bit of background on that and tell us how you think these two debates intersect?
Briefly. Well, it's just been, certainly the sense of the Registrar of Copyrights who issued a report saying that it was time to renew, have a new Copyright Act, and Congress has taken that lead, and Congressman Goodlatte has begun the process. How does it intersect with this? In particular, she is focused on the Copyright Act, but DMCA is, ultimately closely related to the Copyright Act, and so I imagine that they will be taking a look at this as well. I don't know if that answers your question.
Any other comments? Chris?
Well, I think it's probably long overdue. There's a number of issues beyond unlocking. I think unlocking hopefully will be a large part and receive a spotlight in the process that Congress takes on with the copyright review that they're doing. But there are a number of issues. I think, I agree with Jerry. I think it's really interesting that the Registrar of Copyright has said that it would be interesting to look at reducing the copyright term. It has been extended several times from its original intent, and it's hard to make a case to a consumer that someone who's passed away should continue to have protection of their copyrighted material that they are no longer benefiting from for decades and decades and decades. So, there's a great opportunity here to rebalance copyright law, whether it's on terms, whether it's on locking, whether it's on how we deal with takedown notices or damages, and so it's something that we should investigate. Like I said before, I don't think this is something we should do quickly, but it's great that we're having the discussion, and it's great that everyone's being invited to participate in that discussion.
Ryan, do you see some of this this unique bipartisan agreement on cell phone unlocking? Do you see that dissipating when we get into the larger debate about copyright, or do you think it might at least help to set a good tone for having a constructive dialogue?
I think it will be helpful. We've seen how the House and Senate Judiciary Committees working together on ECPO reform, which is a bipartisan issue. Hopefully on copyright.
Privacy issue.
A privacy issue, yes. Hopefully on copyright, the stakeholders can realize that a bill that takes us in the right direction is probably not going to include provisions that any one stakeholder is completely supportive of. But we need legislation reform that moves the ball forward, that makes the Copyright Act better, and that's going to probably have to address both the enforcement problem and also some of the overreaches dealing with orphan works and cell phone unlocking and anti-circumvention.
Okay, one final question from the audience.
Hi, my name is Mike. I'm an intern with America's Future Foundation, and seems to be somewhat of a consensus on balancing the policy to allow for people that are going to, for non-infringing purposes, and yet still holding the penalties for people that are going to be using it for abuse. And there also seems to be a consensus that striking that delicate balance between bringing it from the policy to actual law, it can come through very banged up. Curious, from one of the four, possibly Jerry and then maybe Larry, to what that might actually look like. It seems like there's a lot of, this is the balance we need to strike. What might that actually look like at the end?
Excellent question. We haven't modeled it yet, so I'm not quite sure. I mean, I've been thinking about this issue for quite a while, and, I think one of the challenges in the digital age is that, given the proliferation of the internet, is that you have what I like to call an expectation of free, right? I mean, it's so easy to get content. It's an expectation of free. And as my partner, the economist, would say, free is never the right price, right? There is your problem. And, you have, there are sunk costs involved in making content, both human and actual, capital costs. And trying to find that balance when you have literally a societal expectation of free now. I mean, I want to go online. I mean, I think we've all done this. There's always an expanded use of fair use out there for something on the internet. And trying to find that balance of, again, not, indicting the little old lady who, put up 2 little YouTube clips versus, somebody who just, a major motion picture studio just spent $150 million develop, bringing the next Wolverine movie, and the next day, it's on the internet. So these are the difficult challenges that we have to do is, there's not one homogeneous consumer, and that's the difficulty of the enforcement. And I think there's probably consensus on that.
Okay, I'm going to wrap this up by giving our other panelists brief response. Just, 30 seconds, big picture.
Just briefly, that I completely agree with Larry that 0 is not the right price. Absolutely, which means that we need to have copyright. The purpose of copyright is to give an incentive for folks to create what would otherwise be a public good, right? That could be, you can charge for it. So we need to have copyright in order to do that. The question is, what is the right amount of copyright? And that's a very difficult question to answer. And it's one that, it's especially, Congress is especially probably unsuited to deal with it, but that is who has to do it, because that's who has the power in the Constitution. I do think, though, that we should worry about the grandmas who get arrested for copying a couple seconds of a movie on their cell phones. We should worry about them, and so we should look at, well, what is that a symptom of? It's probably a symptom of overcriminalization, overregulation, and so we should sort of follow that thread. So that's part of that conversation.
I would just add to that, I think, the idea of a culture of free, I don't necessarily subscribe to. I think that, when folks, that generally most consumers are willing to follow the rules when rules are set up that allow them to access, goods and services. So, when we saw, when I in the 90s when I was growing up, we had Napster and people were downloading free music all over the place. Then you have iTunes, and all of a sudden everyone's willing to purchase something for 99 cents. That's an improvement because the structures were set up for it. I think it hopefully will be the same with the update of the Copyright Act for digital ownership and for digital goods. It's important that we allow for some sort of marketplace for digital goods. What it looks like, it's going to be hard to construct. But we have to understand that there's an expectation that people still should be able to go out and buy things. And if that's not out there, then it will lead to more piracy. Creating structures, creating laws that allow for those marketplaces to exist online and offline has shown that it will reduce piracy and people will follow the law generally. Now, should there be protections for infringement for the great pirates out there, people who want it? Yes, absolutely, and we're not saying there shouldn't be. But that's the balance that we're looking to strike from your average consumer that wants goods and wants to be law-abiding to your great pirates. There has to be a balance between the two, and it's a tough discussion. But the technology is out there right now. Let's just put that on the table. The technology is out there for you to buy and sell digital goods, to buy and sell books, music, and movies. It's just making sure that we structure in a way that makes it legal.
Ryan.
Sometimes the bright price for content is indeed 0. Broadcast content is streamed over the air in high definition, of course supported by advertising. Same with a lot of content on the air, on the internet. That doesn't mean that copyright is incompatible with it. Quite to the contrary, copyright sets the baseline. You can watch broadcast content, it's just that there are going to be commercials interspersed with it, although there are some companies that are trying to stop that from being the case through questionable measures. In the context of cell phones, the baseline is, or ought to be, contract law, whether the subsidy should be accompanied with a $350 early termination fee or a $1,000 early termination fee, or whether there should even be phone subsidies. These are all questions about how to price content, how to price cell phones that have to occur through voluntary transactions in the market, through emergent order, subject to a set of baseline rules. Sometimes that's copyright, sometimes that's property and contract.
Well, I'll just say to wrap things up that the emergent order that Ryan talked about is exactly Tech Freedom's theme. It's letting actors build the law that best governs new technologies. And here, that law evolves through a mix of contract law and copyright, actual copyright, not necessarily the DMCA, which, let's remember, was a statutory add-on to copyright. So I look forward to having another event about the overall revision of the copyright rules probably later this year, and you'll see some of the same faces here. And I look forward to seeing some of the rest of you at our event about children's privacy in July and what the FTC's recent changes say about children's media, about privacy more generally, and about how the FTC works and how it builds law for governing the use of our data. Having said all that, thank you again for coming. I look forward to seeing you at other events here at our new headquarters. And please thank our panelists and also Commissioner Pai for joining us today.